Yes. So we've started recording this webinar as well so that it can be utilized for future use as well. So why timely recovery of dues is critical. Outstanding dues don't just block money, they block opportunities. So when our cash flows are not in line, our delayed payments choke not only our operations, but they also stall production, delay salaries, impact our working capital, and that in turn impacts our um, expansion, investment, innovation, and also if the payments are not due, the payments that are due are not paid to us in time, that impacts our compliances also, which are necessary for us to be up to date with our GST filings, our TDS, our other statutory dues. So this not only chokes our operations, but it brings the business to a standstill if not tackled correctly. So this business stress not only wastes time and resources by chasing defaulters, we are not able to concentrate on what is at hand, which is growing the business. So that is why we have to have certain strategies in place. So I will go through 10 important strategies that you should have with when you start a business. But as we are aware that credit business is what very prevalent in the market, because we have to offer credit terms so that we attract more customers, increase market share, establish and foster long-term relationships with our customers. And this has been an industry norm for revenue growth, because if you don't do this, you will not be able to grow. So before you start a relationship, what we generally recommend is assess the credit worthiness of the potential customer or the vendor. Second is check their trade references and payment history. So speak to people in your industries who have worked with people who vouch for their payment history. Second, you can also check their entire balance sheet from the MCA website. Obtain, if they are private or a public limited company, obtain their balance sheet to understand what kind of debtors or creditors that are there in their balance sheet. Always ensure that you take all the KYC documents, not only of the vendor, of the person who you are interacting with, so that later point of time, whenever if some issue arises, you have the correct person, the correct business, the correct addresses where notices can be sent or person can be held liable or accountable. What we see most of the times that there are no legal comprehensive documents in place, but when a relationship is undertaken, and generally it's word of mouth or generally on the basis of purchase order and invoice. But these purchase orders and invoice are at many points of time incomplete, wherein they're missing a lot of terms and conditions on the basis of which your relationship has been established. So these um, documents have to be clearly worded, because what is written will be taken care of or will be looked at the time of a dispute. If there's nothing which is in written, there is no way that you can fall back upon in the time of a dispute. So always have everything in writing. Writing is most important, whether it be over email where you share your terms and conditions, have a comprehensive contract which is signed by both parties. It is essential to do that. And the last, which generally happens for bigger contracts, is having collaterals, bank guarantees, or even for smaller transactions, have a security check in place, because a security check acts as a deterrent for them, because that security check can be deposited in the event of default, and that can hold them liable in a check bounce case if at all it gets dishonored. Sorry, apologies. uh, Best practices during a business relationship. Your invoice must be timely and accurate. That is a must. You cannot not send a proper invoice, and your invoices must contain the following things: your MSME and GST registration number, your due date for payment. Most of the times we notice that due dates for payments are missing, whether you're giving them a 30-day credit period, 45-day credit period, it has to be clearly mentioned and set out. One second, there's some technical issue. I'm just going to try and bring back the PPT. Yes. Statement with reference to acceptance of goods. There should always be a statement within your invoice that mentions that goods once sold are accepted by you unless absolutely rejected for some reason within 7 days, 14 days. Give a period of time in your invoice. Otherwise, deemed acceptance statement should be mentioned. Fourth, interest for delayed payment should be mentioned, whether it be 18%, 24%, 12%. There has to be an explicit mention of delayed payments, interest on delayed payments, because in the event you go to court and in the absence of a interest clause, they will always refer to general interest rates and at many points of time not even grant you interest unless absolutely deemed fit by the court. So it is essential that your contract or your invoice establishes that delayed payments will attract interest. Jurisdiction in the event of dispute. So we may be dealing with people all over the world, all over India, and under the Contract Act, it is mentioned that the dispute, if raised, will be where the defendant lies or where the goods have been transported. And or alternatively, if at all it has been agreed that the jurisdiction will be a particular place. So in the event if we don't mention any particular place for dispute resolution, we will have to go where the defendant is, which is not always accessible to us or always possible for us to undertake. So, in order to be at the forefront of the dispute and have a stronger leg when we get into a dispute, you should always mention the jurisdiction of your office as the place for dispute resolution. This will give us an opportunity to also give the other party trouble, bring them to our jurisdiction for carrying out the resolution. Plus, we will have a strong position at that point of time. Another thing that we always recommend as best practices is have regular communication over email rather than phone call. So, like I said, what is written gets communicated and becomes your evidence in dispute resolution. So, emails are excellent uh, points of sorry emails are excellent ways in which we can record whatever is happening in our relationship. So whether it be delay in outstanding payment, whether it be refuting a particular contract, whether it be raising a concern over goods that we have received, so that email becomes our communication point or written rejection or written approval or written reminder to the other party for payment. Main accurate documentation including Maintain accurate documentation of sale including the initial contract, purchase orders, invoices, delivery challans. These create your entire set, basically, which you have to maintain for each and every transaction you undertake. So for example, if at all we go to court at a later point of time, we have complete evidences of what our initial communication was, what was the purchase order exactly provided us for, what kind of invoice did we raise one invoice, did we raise multiple invoices, and whether that after during raising that invoices has the goods actually been delivered to them. So the delivery challan shows proof that delivery of goods has also undertaken place. Another thing that we also recommend is If at all your clients are asking for more time for payments, higher credit periods, offer small discounts for early payments, offer these kinds of schemes to them, which will make them pay your dues on time or before time. And offer flexible payment options for large dues. So flexible payment options are such as basically NEFT, RTGS, check transfer, partial payments, um, monthly payments, 15-day payments, things like that, which give them the opportunity to not pay large dues all at once, but also not stop your payments completely if at all they want to stop them. So we also recommend that a collection process should be established in every organization in order to maintain your debtors to the lowest. So what we generally do is there has to be establishment of amount due. Second step should be initial communication through letters, emails, phone calls, and all of this should preferably be recorded over the email. So, for example, if you undertake a phone call with an officer of the other party, and after the phone call, we always recommend that send a follow up email to put them on notice saying that we had a conversation with XYZ person of this particular company on this particular date at this particular time, and this is what we discussed. So this will keep them at in attention, saying that this has actually transpired and they cannot refute or reject it in the future. And this should be done instantly. You shouldn't wait for a day or two to send this email. It should be sent as soon as your call gets over. Send reminder emails at regular intervals. So you should also always, in the event of long credit periods, and if payment has not been made, for example, in 30 days, there should be a regular reminder which has to be issued every 3 days for the first 7 days, every 2 days for the next 7 days, and every day following 14 days. This will showcase our intent. This will showcase our reminder process. And also, if at all after 30 days the payment does not come in, you can escalate this by issuing a legal letter slash email threatening legal action. So this generally should be issued by a senior officer rather than an accounts official from the organization, and this should be addressed also to a senior official of that particular organization to show that there has been an escalation that has taken place, and these dues are in the eyes of the promoters or directors of the company. And if that also does not work, issue a demand notice through a law firm. So our intent generally is to not involve legal processes till they are absolutely necessary. Payment delays are often justified with repeated excuses, leaving businesses uncertain of cash flow strains. So, disputes around product quality, delivery timelines, service level frequently become grounds for withholding payments. And weakly drafted contracts with vague payment terms or no enforcement provision make recovery really, really difficult. So we always recommend them to have contracts in place that they are enforceable at a later point of time. Businesses often also lack an internal follow up mechanism, leading to inconsistent reminders or lost leverage. So that is why we always tell them to create a follow up mechanism within the organization which will do all of these steps on a regular basis. And once that system gets set up, your machine works like a smooth, well oiled machine. Another thing that we always hear is fear of damaging business relationship causes companies to hesitate in taking strong recovery actions. So we always hear this is a big client, they do big business with us. We don't want to antagonize them. We want to keep doing business with them, but we also don't want to be very harsh. However, our recommendation is business will keep happening. However, if your outstanding dues don't come to you, you will not be in the position to do that business. So always have a system in place. If you want to give some leeway to them. If you want, not give 15 days but give them 30 days, 45 days, 60 days, 90 days. Establish what your leeway is going to be prior to you taking next steps. But once you reach that step of 60 days that you've provided additionally to the 30-day credit, you should take additional steps. Otherwise your money is getting stuck, your money is being utilized by them on a regular basis without you having that opportunity to use that money, which should not be done. So, like we always say, regular communication over email rather than phone calls is important. So, what we do here at ATMS, we follow a well established 10-step system. I will not take you through the whole 10 steps, but we will generally give you a broad overview of how we do these recovery processes for our clients. We do an initial consultation. We ask for different documents from them. We do a document review on the basis of the documents that they provide. We do a debt analysis of how much is actually due, when it became due, how much interest is pending, what we are liable to receive at the end of the day. Then we draft an internal email for them, which has to be sent from the company to the other side. We do not get involved at this level. We will assist them in drafting those well drafted legal emails, which can be issued to them. So if they respond to it, we assist with negotiation and settlement. We follow up. We do follow up calls. We monitor the compliance if at all there is a settlement, and then we entirely close the issue. But if they are not responded, if for example they come settle with us, enter into settlement terms, and they breach it, we issue a demand letter from the law firm, call from the law firm to the debtor, issue a final demand letter, consult you on what legal action can be taken, and then we assist you in taking that decision as to what action needs to be taken next. So there are various legal modes of recovery. I will take you through them. One is MSME Samadhan, one is Insolvency and Bankruptcy Code IBC, one is the Commercial Courts Act, one is check dishonor, and one is arbitration and conciliation. So, over and above this, we also have various remedies which are available, which acts as pressure techniques on the other side, which help us into forcing them into settlement. These involve using the GST authority to build pressure on them, because if we use these strategies, their funding that they're obtaining from the banks also gets impacted because of what kind of communication we do with the GST department. So we've done that for a couple of our clients, and the kind of pressure that builds on them helps us settle these matters quickly. So if at all anyone wants to understand how to do this, feel free to reach out to us after the webinar. We will happy to assist you. So the MSME Samadhan helps with micro and small enterprise prices having Udyam registration. And this Udyam registration can be done through the online portal that is available. So once you're an MSME, if at all your payment does not come within 90 days from the date of 45 days of your invoice, or the time that you've agreed in your invoice, then you can file an application to MSEFC, which is the facilitation council which has been set up, and they have to address these issues within 90 days from making such reference. And after the application has been made, they issue directions to the other side along with interest at um, along with interest which is compounded. So this becomes an advantageous part for us, because the compound interest is levied at 3 times of RBI rate, so which is approximately 19 to 20%. So that becomes a good interest rate also for us. And plus, at the same time, when they're referring to MSME Samadhan, this reference also gets showcased and portrayed in their balance sheet, and they cannot avail um, what do you call expenses on the basis of these expenses in their balance sheet. So this helps us create that sort of a pressure on them. Even though the process has been defined as 90 days, it takes much longer. However, it is a very safe way in which we can approach the entire organization, the MSME Samadhan portal. So the MSME Samadhan works in a in this manner. This photograph is available on their website as well. So entrepreneur files an application. After 15 days, council will take action on the application. Online intimation will be sent to both you and the respondent by email. Mutual settlement option will be available. Council will approve whether the application has to be converted into a case or not. The council can reject also the entrepreneur's application if they don't have all the documents in place. So that is why, if you recollect in the beginning, we talked about having all the documents in order, because that will assist you when you want to undertake any legal action. After that, SMS and email will be sent to the entrepreneur and respondent if an application is converted into case. Then both parties will file their responses, and hearing dates will be set, and then after the conciliation, an award will be passed. The next one is insolvency and bankruptcy code. The insolvency and bankruptcy code is a not a debt recovery procedure per se, but it is a pressure technique wherein we go to the court saying that the other party is not paying our dues, and they should be declared insolvent or bankrupt because of their inability to pay their dues. So the claim amount should be more than 1 crore. It should be a private public limited company and against which we can file this application. And once we file the application, an IRP, which is an interim resolution professional, is appointed to take care of the business of the other party. So this means that the entire business goes out of the hand of the promoters and falls into a third party's hand, which a company who is a running concern would not generally want. So that is why once we file an insolvency and bankruptcy application, parties come and try and settle their matter out of court before the resolution professional is appointed, so that they do not want to get into liquidation, or they want to avoid going into this process. So this also creates a pressure technique on them. Next is the Commercial Courts Act. So the Commercial Court Act has a very great provision which is called a pre-institution mediation. So pre-institution mediation is a very inexpensive process which has been made available, where your outstanding dues are more than 3 lakh. Sorry. Your outstanding dues are more than 3 lakh rupees. So pre-institution mediation can be filed at just a standard court fee of 1,000 rupees. So making it a very accessible way, and also a route wherein you don't pay excessive court fees, and also get some kind of an opportunity to mediate or settle the entire issue prior to instituting proper litigation under the Commercial Courts Act. And this has become a mandatory process unless there is a urgency which can be showcased that why you don't want to do this pre-institution mediation. And also another part which is very special is if the other party does not file a written statement. So after we go to pre-institution mediation, the person does not turn up there, and we end up filing a commercial suit against that party. And once the party has been served with the complaint and they do not file a written statement within 60 days with a maximum of 120 days, then their response will not be taken on record. And this has been kept, and through various jurisprudence, through various judgments, it has been upheld. even in the Supreme Court, that beyond 120 days, no written statement will be honored. So this becomes another most important way of recovery through civil means. So, civil means, if at all you want to take for recovery, then this is the way you should approach it. Next is proceedings under the Negotiable Instruments Act, which is a check dishonor case. So this is a criminal proceeding which we don't generally recommend to our clients, but sometimes it becomes necessary in order to create that pressure upon the other side uh, to file a criminal complaint under Section 138 of the Negotiable Instruments Act. However, once again, we do not recommend this because after filing, your uh, court cases can go on for years and years altogether without much relief to you. However, it is a criminal proceeding. You can file additional applications to pressurize them, to basically stop them from traveling abroad, to creating some kind of undue pressure to come to police station on a regular basis. Things like that, have shorter dates so that they have to make themselves available to come to court. So that ways it it can act as a pressure strategy, but then again, it takes a long time under 138 proceedings. Last is arbitration proceedings. Arbitration is a great process in which you can try and settle your matter outside court without undergoing the entire long litigation process, because litigation will take time. And if we don't want to waste our time, we can have an arbitration clause placed within our contracts wherein we can refer any dispute to arbitration. But in the absence of arbitration clauses in the contract, we will not be able to proceed to arbitration unless the other party agrees through a separate document. So arbitration is, or alternate dispute resolution methods like conciliation or mediation, are great ways to settle matters outside court, utilizing the court's machinery, such as using ex judges or senior counsels or senior lawyers in the fraternity to act as arbitrators or mediators to settle a particular disputes. And these arbitral tribunals, when passed, are binding in nature on both parties, and it can give you a relief also in a quicker manner. So this is a great legal maxim that I always tell my clients. It means that the law only helps those who are vigilant and not those who sleep. So, creditors must be aware of their legal rights and act upon them within prescribed periods of limitation, and utilize the machine mechanisms available, such as MSME Samadhan, Negotiable Instrument Act, IBC, because you should know that there is a period of limitation that comes in when there are outstanding dues. So, if you're aware that 3 years after your last payment or admission of debt or acknowledgement of debt is your limitation period. Beyond that, you will not be able to claim any amount. So, for example, if you have certain amounts from 2021-22, which you have not received yet, and you have not received any kind of confirmation from the other side, then you are in default because you have not taken any legal action against them, and you will not be able to claim it after your 3 year period is over. So it is important to combine preventive strategies with legal avenues for an effective recovery process. So I think I have covered a lot of things very quickly and in a very concise manner. I would love to take some questions from all of you, so that we have a more interactive session. Any questions?
Hello.
Yes.
Yeah, hi, good evening, sir.
Good evening.
My name is Umesh and I am from 10x Fire Solutions from Gujarat.
Sorry?
My name is Umesh and I am from 10x Fire Solutions from Gujarat,
Yes.
sir.
Yes.
Actually, I want to brief about this commercial court act. How can we apply it for file? Is it through portal or we have go through a lawyer or any counsel? Can you
No,
please
so
brief on that?
MSME portal is available, and it is a very simple process to obtain the MSME certificate, MSME registration certificate. You can reach out to us after this call. Our team can assist you with how to undertake the entire process.
No, I am asking for the commercial court act. So is
Sorry?
it I am asking for a commercial audit to 2015.
Okay, with reference to Commercial Court Act, it is generally recommended that you go through a lawyer and not directly, because there are various intricacies that you may be missing at that point of time. So a lawyer will be able to assist you as to how to surpass those.
Okay. But is there any portal available for this?
No, so it has to be filed with the city civil court of that particular jurisdiction. So, for example, if you're in Mumbai, there is Mazgaon court where you will have to file. And if you're basically around Borivali or Malad or Andheri, then you will have to file it with the Dindoshi City Civil Court Mediation Council.
Okay, sir. Not it. Thanks. Thanks, sir.
Yeah.
Yeah, Punit.
Uh, yes, I think I see Mihir.
Yes, Puneet. Hi. Good evening, sir. How are you?
Good, good. Hi, Mihir.
Am I audible, Puneet?
Yes, yes.
Puneet, we are into real estate. I'm coming from, we are based out of Ghatkopar, and it's a small firm, home loan property consultant. Really, Puneet, we face a lot of issues with regards to these outstandings, wherein sometimes we come across a situation wherein both the buyer, seller, purchaser, they kind of become one and they try to put us the sideways and complete a transaction, and we fall into such a way we don't have any option but to just stand still, considering we need to think of our reputation in the market. And so we face a lot of difficult situations like this. So generally, just to take a heads up in terms of how do we or what can we do to particularly avoid this, or how can we safeguard probably in a small point, how can we avoid this thing?
Correct.
I mean,
So
we try our
my
best to create a term
my
sheet. We
my
try to
recommendation generally in these situations is whenever you onboard someone who wants to purchase or sell a property, you should enter into a contract with them stating that it will be your duty to provide them with names of potential buyers or sellers and what your particular service fee will be like. So it does not have to be a very long detailed document, but an
understand.
onboarding documents of sort, wherein you are onboarding them as a potential client, and whoever you share with them should be recorded over email stating that you made them meet this person today. So later on, if at all you want to utilize that particular document stating that this was the buyer, this was the seller, and you are entitled to your
A
service
commission.
fee or
Yeah.
brokerage at that point of time, that creates your entire trail, which becomes evident if at all you end up pursuing legal route.
And so kind of a small MOU can be would suffice to go into a situation if we come, would
No,
a small
so
MOU
we
be
do not recommend MOUs. We recommend a contract. So you can call it a service agreement or a service contract wherein you are providing a service. So
okay?
don't name it an MOU, name it an
And
agreement.
okay, do we need to register this agreement or a normal on a paper of stamp paper is good enough, or a legal paper?
A 500 stamp paper is good enough.
500 stamp paper is good enough, right?
Yes.
Also, just wanted to understand, we tend to record calls or automatically record the discussions what we do with client, purchaser and seller. So in that case, are these recorded calls legal enough to prove our service, or they are not suffice, or they are not, I mean, legal in the court?
So they are legal, but they can be challenged also. So we always recommend a written document for these
Okay.
things. You can bring them into evidence, but their validity and acceptance depends from courts to court.
Okay. So what you suggest is email is the best option wherein you get everything in
Yes,
written,
I
either email
highly
or on
recommend
service
using
contract.
emails.
Okay. Does it have to be personal email ID, or any email ID is fine, right?
Any. Provided that there is a confirmation from them as well.
From
So
them,
that
from the
it should
party.
not be a one-sided communication.
Right. Understand that. Thank you so much.
Hey, hi. Hello.
Hi, Manjunath. Yes.
Yeah, I'm Manjunath. I'm from Bangalore.
Hi, Manjunath.
See, we are an MSME. We are into the food manufacturing industry. In my case, there are two customers has picked the material, and they have not paid me from 22, 23 onwards, and their operation is closed. Point number one. Point number
Okay.
two, I have raised a valid invoices and I have supplied the material. I don't have an acknowledgement for having delivered the goods. Point number
Okay.
three, I don't have any proper purchase order. There are mail communications stating that you supply that's in bits and pieces. So my outstanding is almost 2 lakh rupees with these two customers.
Hmm.
They are not responding to any of my mails or they are not picking my calls.
Okay.
So
So,
how do I recover this money? Because I have tried through MSME Samadhan portal,
hmm.
and that
Yeah.
portal also there is a timing in that. Say that sometimes the period which offers, which is off late. The earlier period, say around 23, 20, 22, 23, it is not taking. How do I proceed further?
Correct. So, Manjunath, I think this is a very specific issue. What you can do is you can reach out to our team.
Hmm.
I will share the email ID. You
Yeah,
can send in your details to us. We can have a discussion after we have a look at your documents.
yeah. Thank you.
Punit, hi, I'm Ashok Doshi here. Uh,
Yeah. Hi, Ashok.
yes. My question is that you rightly said that IBC and MSME Samadhan for solution.
Yes.
But what about
Ashok, unable to hear you.
the international business which we are doing, overseas?
Correct. So
Is
that
there
is why my
yeah.
recommendation is always having a jurisdiction clause
Hmm.
in your invoices and in your contracts, wherein the jurisdiction that is claimed is Mumbai.
Hmm.
So
Okay.
when your jurisdiction is Mumbai for disputes, you can always file any kind of complaint or claim against different avenues that are available to you. So for IBC, you have to file it where the defendant is located. That is the law, regardless of whether your dues were raised there or not. But however, for other places, it can be the jurisdiction can be decided through contract.
Okay. But suppose I'm doing business in Africa or Nepal and other countries. So is there any procedure?
Ashokji, your
Special,
voice is cracking.
suppose I'm doing business internationally. Are you getting my point? Hello.
Yes.
Suppose I am doing international project. Hello.
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 I'm audible.
Ashokji, I think there's some network issue from your end. If you could reach out to us offline, we can have a conversation.
Okay. No
Yes.
problem.
Okay. Can I raise my question?
Yes, Rajesh ji, right? Correct.
Yeah. Sir, I'm in Mumbai also, and I have my two of clients. To with
Yes.
them, I'm working from so many years.
Mm-hmm.
Very good relations were there, but I don't know why. So every time they used to pay me after 5 to 6 months, even if in my invoice it is written that 30 days is my payment terms. After that, 18% interest will be charged. But we never ask you for that. But now, some 1 year ago, our business is stopped, and they are not paying me last payments. So, and they are not giving me proper answers also. So I've heard your procedures which you told me, commercial code as well as MSME portal, everything. But I want to ask you one thing. When clients are not giving you proper answer, that okay, this is the problem, we will pay you a payment only after this the issues were settled. They are not giving anything. They are just putting, some. They are not sometimes replying me also. So I want to ask you, can I go in a criminal court with or civil court with the harassment case? Because actually they are harassing me. They don't have any proper answer. For this reason we have stopped your payment. And one more thing, if I go to them, so can I ask for their uh, paid payments which were 5 to 6 months late? Now I can ask for the interest. So I two questions are there. Can I
Yes.
go for a harassment and mental agony wise complaint? And second thing, can I ask for that late payment interest?
Understood. So, with reference to your second question, you cannot
Yeah.
ask for interest for what you have already received and you have not raised any disputes. So, that
Okay.
clears that. With reference to mental harassment, uh, what happens in these cases is even though there is actual mental harassment happening to you, if you go to the police station, the police will claim that this is a civil matter and you should approach civil courts, and it is not a criminal issue. So that is why generally when there are matters of money which are based on contract or invoices, these are generally referred to civil courts, and criminal police don't take jurisdiction of these issues. So
Okay.
you will not be able to do that. However, considering that he is not responding to you, we recommend that uh, a strong email has to be sent from your end in a legally drafted language to them to make sure that this matter has escalated to a point where litigation is the next step, and that way you will understand where they stand, and if at all they respond, and if they still don't respond, our recommendation is to issue them a legal notice
Yeah.
and then take the process as it goes.
Okay. Okay. So now only have to go legally by civil court.
Correct.
Okay. Thank you.
All right. I'll take one last question if at all there is any. Perfect. So I think we are done with all questions. Um, I have left my email ID on this particular chat box, and you will also get our contact details in email after this call, so that if at all you all have any other queries, happily reach out to us. We will be happy to answer and assist you in any way possible. Thank you, everyone.
Okay. Thank you very
Thank you.
much.
Thanks a lot, Rajesh. Thanks.
Thank
Thank you, Punit.
Thank you.
Thank you.
Thank you, Suyo.